different changes which we have brought of late. One is that we have started certain sessions at 9 p.m. because life has come back to normalcy, we can say. But as they say that you have to still take the precautions. COVID, though undoubtedly has come down, but as they say, prevention is better than cure. And second is that we have also started taking sessions which are in different languages, that is Hindi, and we also started one session in Punjabi. But today we are back with the English session. And as the session itself speaks, the effect of foreign judgments in the matrimonial cases under section 13 of the Code of Civil Procedure. And amongst us, we have Parvati Menon, an advocate from Kerala High Court. And we have already seen that the way, in a subtle manner, she explains the issues and aspects. And this aspect as to effect of the foreign judgments is an issue which normally keeps up cropping for the purposes of professional also, and at least to ignite the, as they say, the legal minds. And legal minds, when they say we have a different issue, is always a fascinating subject as such. Since we are starting late time, I will just ask Advocate Parvati Menon to take things in her usual manner, which is simple and self-explanatory. She would also be sharing the notes on the screen sharing. Thank you, friends. Stay connected and stay blessed. Those who have missed the previous sessions, they can always subscribe to the Beyond Law CLC YouTube channel. Over to you, ma'am. Unmute. Unmute. Unmute.
Good evening, all. Namaste, Ji. And my beloved senior, Mr. Ramachandran, he has joined this evening. Actually, he's a retired judicial officer. So I'm so happy, sir, that you have also joined. And namaste and good evening to everyone. This, I suppose, it's a very interesting topic, because when I came to know that this flyer had reached many of my colleagues, I was told by many people that this is an area which created a lot of confusions among a lot of litigants as well as lawyers. But I think if you really look into it, and if you really go through the decisions also, it's actually very clear. Only thing is how you are able to apply the specific law to the circumstances or to your case law, and that is to your particular case. That alone is something which we will have to develop. Otherwise, I think the law is absolutely clear and it's a settled position as well. So if I may be permitted to share the screen. Okay, now the effect of foreign judgment in matrimonial cases under section 13 CPC. That is the topic of the day. So I'm not able to screen share. Yes. Now, what does section 13 CPC say? Like, if you go to the definition of, or rather the contents of section 13 CPC, I think it's better that if I give you an idea about section 13 CPC in a more simple manner. Now, if you go to the contents of it, it says, when foreign judgment not conclusive, it's more of a negative definition or a negative manner in which this provision has been highlighted. A foreign judgment shall be conclusive as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them claim litigating under the same title, except, so let us read it this way, where it has not been pronounced by a court of competent jurisdiction. So one aspect is, if a foreign judgment has to be accepted in India, it has to be pronounced by a court of competent jurisdiction. Secondly, it has to be given on the merits of the case. Thirdly, it appears on the face of the proceedings to be founded on an incorrect view of it should be on a correct view of international law, but more when it comes to the usage in India. A refusal to recognize the law of India in cases in which such law is applicable. If the foreign judgment which we intend to be accepted in India refuses to recognize the law of India, where in cases where such law is applicable, then the judgment cannot be accepted in India. I can explain this to you by means of a case. Of course, I'll come to that. Then you have where the proceedings in which the judgment was obtained are opposed to natural justice. That is a part of civilized litigation. As you all know, that principles of natural justice have to be followed when it comes to any kind of civilized litigation. Then if you have obtained a judgment by fraud and where it sustains a claim founded on a breach of any law in force in India. So these are the conditions by which on which a foreign judgment can be treated, whether it should be considered to be conclusive or not. So a foreign judgment can be considered to be conclusive and acceptable in India only if, one, it has been pronounced by a court of competent jurisdiction, it has been pronounced on the merits of the case, it has been pronounced without refusing to recognize the law of India in cases in which such law is applicable. It has to be pronounced after following all the principles of natural justice. It should not have been obtained by fraud, and it should not have caused any kind of breach of any law in force in India. So these are the basic concepts on which Section 13 CPC lies. Now, I will straight away take you to the Magna Carta of the conclusiveness of foreign matrimonial judgments. That is why Narasimha Rao and others versus why Venkatalakshmi and another. It's a very detailed judgment, 1991 Supreme Court cases 451, which still is considered to be a Magna Carta in this issue regarding this matter, because it covers all the different sections under Section 13 very absolutely separately. So it will be more easier for us to understand. It gives an explanation to each subclause of Section 13 so that it becomes more easier to comprehend. So this, I'll take you to this particular judgment. The Honorable Supreme Court in the above case has elaborately discussed the applicability of Section 13 of the Code of Civil Procedure as regards foreign judgments on matrimonial disputes, particularly in light of the Hague Convention on the recognition of divorce and legal separation. This judgment continues to be the Magna Carta on the conclusiveness of a foreign matrimonial judgments in India under Section 13 CPC. See, Section 13 CPC covers the acceptance of foreign judgment regarding all issues, but today, this class, we focus only on the matrimonial concepts. Then Section 13A interpretation. Section 13A interpretation, as I told you, from the section when I read out the section itself in the of the CPC, this interpretation, when it comes to the judgment, it reads: Clause A of Section 13 states that a foreign judgment shall not be recognized if it has not been pronounced by a court of competent jurisdiction. The court continues: we are of the view that this clause should be interpreted to mean that only that court will be a court of competent jurisdiction which the act or the law under which the parties are married recognizes as a court of competent jurisdiction to entertain the matrimonial dispute. Now let's get back. Like we all know, in India, we have personal laws that govern marriages and succession. So we have the Hindu Marriage Act, we have the Divorce Act, Christian Marriage Act, Divorce Act, and then we have the Sharia law, and also we have, of course, now the dissolution of Muslim Marriage Act is there as early as 1939. Then subsequently we have also have now the act that that holds that triple talaq is bad in law. And so which court, which is the court of competent jurisdiction has to be decided on the basis of which court should be recognized as a court of competent jurisdiction under the law under which the parties have married. For example, as far as Hindu marriage is concerned, we know the court, there are different subsections which says you can file a court, you can file a case for divorce before any before the family court, either where the marriage was solemnized, or where the parties lived together last as man and wife, or where the petitioner resides at the time of filing of the petition, or where the respondent resides. So these are all courts of competent jurisdiction which has been recognized by the law prevalent in India. In case of divorce also, in case of divorce, under the Divorce Act for the Christians, also this applies. So when it comes to when it comes to section 13A, you have to interpret it in such a manner that a foreign judgment shall be recognized only if a court of competent jurisdiction has pronounced it. Any other court should be held to be a court without jurisdiction unless, this is very important, unless both parties voluntarily and unconditionally subject themselves to the jurisdiction of that court. For example, the marriage took place in India, and then the parties are residing in Australia. Both of them decide to go, or rather approach the court of law, and before the court of law, both parties voluntarily subject themselves to the jurisdiction of the Australian court, or unconditionally subject themselves to the jurisdiction of that court. Unless and until they voluntarily or unconditionally subject themselves to the jurisdiction of that court, the judgment passed by that court cannot be accepted in India, because ordinarily it is the courts in India which will have the jurisdiction over to decide the whatever aspect that relates to marriage as far as those two parties are concerned. But if they choose, and if they voluntarily and without any condition subject themselves to the jurisdiction of Australian courts, then of course that judgment can be considered before the court of law here, or rather that can be accepted here. Then comes how the interpretation of section 13B is considered in that particular judgment. That is the 1991 judgment. Clause B of section 13 states that if a foreign judgment has not been given on the merits of the case, the courts in this country will not recognize such judgment. Like an ex parte judgment, the other party was not present, and the court passes a judgment behind his back, or rather in his absence, that will not be accepted by the court here. This clause should be interpreted to mean, one, that the decision of the foreign court should be in a ground available under law under which the parties are married. This is very, very important, because as you all know, in India, the concept of marriage is absolutely different when compared to other foreign countries. So there are an array of grounds on which an Indian can get, or for that matter, a Hindu or a Christian or a Muslim or a Sikh or a Parsi can get a divorce. There are separate laws. Then, of course, we have a Special Marriage Act as well. But normally, the grounds for divorce almost are similar. They range from cruelty, which amounts to mental cruelty, physical cruelty. Then it ranges to adultery. Then it comes to cruelty coupled with adultery. Then it comes to conversion of a person, a case where the spouse has been found to be mentally deranged in such a position that it is dangerous to the life of the other spouse who is expected to live with the spouse who is mentally deranged. So these are the several conditions on which the Hindu Marriage Act, the Divorce Act, and the Dissolution of Muslim Marriage Act, all these statutes spin itself. But when it comes to Western countries, or when it comes to foreign countries, most of these grounds are not used, or rather they're totally unheard of in most of the other countries. So what happens is, what we find in most of the Western countries, at least in Western countries, we find an irretrievable breakdown of marriage is considered to be a proper condition, or a good condition, or a normal, regular condition for getting divorce of the marriage. If both the parties come to the court and they admit that there has been a irretrievable breakdown of marriage between them, it is accepted by the courts in many of the foreign courts. So what happens is, if Indian parties, both Indians, let's take an example, X and Y, they get married in India, they get settled in Australia, and then they voluntarily subject themselves to the jurisdiction of the Australian court. But the ground on which their marriage is dissolved is irretrievable breakdown of marriage. But that cannot be accepted in India, because as per the Indian laws, irretrievable breakdown of marriage is not a ground for getting divorce. Now, again, you all might be confused, because you must have heard there are an array of decisions which I'll take you to, by which the Supreme Court has been granting divorce on the ground of irretrievable breakdown of marriage. But one thing what we should see is, all those cases, the Supreme Court has given divorce or granted divorce on the ground of irretrievable breakdown under Article 142 of the Constitution of India, which is the inherent power of the Supreme Court. Unless and until a judgment is passed under Article 141 of the Constitution of India, it does not become the law of the land. Whatever that becomes the law of the land is only under Article 141 of the Constitution. For that matter, any judgment on merits becomes a law of the land under Article 141. But a judgment, or rather an order passed by invoking Article 142 of the Constitution, is invoking the inherent powers of the Supreme Court. So the Supreme Court alone has the power to grant divorces on grounds of irretrievable breakdown of marriage. So it does not become the law of the land. Though there has been a lot of attempts by law commissions, I think that even the latest 210th law commission. Subsequently also, what I understand is there has been an array of decisions where law commissions as well as the high courts and Supreme Court has been attempting to recommend to the legislators to bring in this, that is the irretrievable breakdown theory, as one of the grounds for a valid divorce. Nothing has been happening so far. It still continues that we do not have this as a ground for a valid divorce. Now comes clause B. The decision should be a result of the contest between the parties. So it should not be a case, it should not be a consent decree. So these are all conditions under which has to be complied with if a foreign decree has to be accepted in India. So please see clause B. The decision should be a result of the contest between the parties. The latter requirement is fulfilled only when the respondent is duly served and voluntarily and unconditionally submits himself herself to the jurisdiction of the court and contests the claim or agrees to the passing of the decree with or without appearance. A mere filing of the reply to the claim under protest and without submitting to the jurisdiction of the court or an appearance in the court either in person or through a representative for objecting to the jurisdiction of the court should not be considered as a decision on the merits of the case. Let me I'll give you an illustration. That's better. Now, X and Y married in India, they unconditionally subject themselves to the jurisdiction of Australian courts. The husband, he files a reply to the claim made by the wife and says it is under protest. I protest. I do not submit myself voluntarily to the jurisdiction of this court, and I object to the jurisdiction of this court. If that be so, just because he has appeared in the court through either himself or through a representative, does not comply, or rather cannot be considered as having complied with the second limb of clause B of section 13. That is, the decision should be a result of the contest between the parties. Just because he appeared through a lawyer and he filed a reply for it's a claim under protest, or if he appears and says that he does not submit himself to the jurisdiction of the court, he protests or he says that he is objecting to the jurisdiction of the court, then it cannot be considered as a decision as a result of that requirement is fulfilled only when the respondent is duly served and voluntarily and conditionally submits himself. Otherwise, if it's a case of pure contest, things are different. Then comes section 13C interpretation. So section 13C has two limbs again. The first part deals with private international law, which does not directly get itself involved in the matrimonial issues in India. So I have narrowed down this point just to the second part of clause C of section 13, which states that where the judgment is founded on a refusal to recognize the law of this country in cases in which law is applicable, the judgment will not be recognized by the courts in this country. It's more or less a kind of repetition which says that unless the law of the land, the law of India, unless you get a divorce on a ground which has been accepted by laws in India, the foreign judgment may not be accepted or applicable, will not be applicable in India. The marriages which take place in this country can only be under either the customary or the statutory law enforced in this country. Hence, the only law that can be applicable to the matrimonial disputes is the one under which the parties are married and no other law. When therefore a foreign judgment is founded on a jurisdiction or on a ground not recognized by such law, it is a judgment which is in defiance of the law. Hence, it is not conclusive of the matters adjudicated therein and therefore unenforceable in this country. That is, as I told you earlier, as I gave you that example of on some ground which is not accepted by personal laws of India, if a foreign country or a foreign court gives a judgment for divorce on some ground which is not accepted by the laws of India, then that judgment is not applicable or cannot be accepted in India. So that's a nutshell of the whole thing. Then comes section 13D interpretation. That, of course, as I told you earlier, it's a very common thing. It's a very wide aspect which is used in all forms of litigation. As I told you, it's a civilized system of justice. That is, the principles of natural justice have to be followed. Clause D of section 13, which makes a foreign judgment unenforceable on the ground that the proceedings in which it is obtained are opposed to natural justice, states no more than an elementary principle on which any civilized system of justice rests. However, in matters concerning the family law, such as the matrimonial disputes, this principle has to be extended to mean something more than mere compliance with the technical rules of procedure. If the rule of audi alteram partem has any meaning with reference to the proceedings in a foreign court, for the purposes of this rule, it should not be deemed sufficient that the respondent has been duly served with the process of the court. It is necessary to ascertain whether the respondent was in a position to present or represent himself or herself and contest effectively the said proceedings. That is the difference. Here, once the notice is served on the opposite side, it is considered to be sufficient method of complying with the principles of natural justice. But in foreign country, I mean, if a foreign judgment has to be accepted in India, clause D of section 13 has been interpreted by the Supreme Court in such a manner that it is necessary to ascertain whether the respondent was in a position to present or represent himself or herself and contest effectively the said proceedings abroad. If you want a foreign judgment to be accepted in India, as far as that case is concerned, you have to make sure that the respondent was served with a notice and that he was in a position to present or represent himself or herself and contest effectively the said proceedings. This requirement should apply equally to the appellate proceedings if and when they are filed by either party. If the foreign court has not ascertained and ensured such effective contest by requiring the petitioner to make all necessary provisions for the respondent to defend, including the cost of travel, residence, and litigation where necessary, it should be held that the proceedings are in breach of principles of natural justice. See, in foreign countries, it goes to a very large extent where it's the petitioner to have to go to see to it that the respondent is brought to the court with all royalty, is able to defend by giving him the cost of travel, residence, and litigation. It's made sure that the respondent has been brought to the court. He has been given sufficient chance to litigate against the petitioner, and only then it will be considered that the principles of natural justice have been complied. And unless and until the principles of natural justice have been complied, that particular foreign judgment will not be conclusive and will not be accepted in India. Then the next interpretation is section 13E. The provision of clause E of section 13 of which requires that the courts in this country will not recognize a foreign judgment if it has been obtained by fraud is self-evident. See, this fraud is not just section 17 fraud. Section 17 of the Indian Contract Act defines fraud. So whatever that comes under the definition of section 17 of the Indian Contract Act alone is not fraud as far as the interpretation of section 13E of by the Supreme Court is concerned. Because, however, in view of the decision of this court in Srimati Satya versus Teja Singh, that is reported in AR 1975, Supreme Court 105, it must be understood that the fraud need not be only in relation to the merits of the matter, but may also be in relation to jurisdictional facts. Because as we all know, jurisdiction is a very important aspect when it comes to matrimonial disputes. It can be either jurisdiction uh, 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 by domicile, or it can be a case of jurisdiction by the celebration of marriage, or the solemnization of marriage can be in a place. That place can get the jurisdiction of the courts, or it can be a case where the party's domicile. Now, in this particular case, what happened was Satya versus Teja Singh, the 1975 Supreme Court. What happened was this case, this particular appellant, that is this particular person, Teja Singh, the husband, actually, the husband who is the respondent before this court, before the Supreme Court, what happened was he invoked the jurisdiction of a particular court, a particular foreign court, by playing fraud on the court by stating that he is a domicile of that particular place, and that domicile was a transit domicile. Actually, he belonged to India, and he was working totally in a different country. And what he did was, a transit domicile was chosen by him, a transit country was chosen by him, and he gave the domicile of that country and obtained fraud on that court and obtained a foreign judgment. It was only when the wife brought this to the court's notice, it was found not on the merits of the case. That is the difference. It was not on the merits of the case, it was even on playing fraud on the jurisdiction of the court also matters much when it comes to acceptance of a foreign judgment in India on the ground of fraud. That is section 13E of the interpretation of section 13E of CPC. So the conclusion is, from the aforesaid discussion, the following rule can be deduced for recognizing a foreign matrimonial judgment in this country. The jurisdiction assumed by the foreign court, as well as grounds on which the relief is granted, must be in accordance with the matrimonial law under which the parties are married. So it should be on some ground which has been given by the Hindu, which has been provided by the Hindu Marriage Act, or it should be on some ground either which has been provided by the Divorce Act, or Dissolution of Muslim Marriage Act, or the Sharia law. So it should be on the basis of some law that has been accepted or provided by the courts of by the law of India. The exceptions to this rule may be as follows: where the matrimonial action is filed in the forum, where the respondent is domiciled or habitually and permanently resides, and the relief is granted on a ground available in the matrimonial law under which the parties are married. Again, twofold. If a matrimonial action is filed in the forum where the respondent is domiciled or habitually and permanently resides. For example, let's take a case where X and Y got married in India. Now they are living presently in Australia, and X wants to get a divorce from Y. Y is continuously or habitually and permanently is residing in Australia. So X can file a suit for divorce against Y, and relief is granted on a ground, and it's not or, that's the difference. And a relief is granted on a ground available in the matrimonial law under which the parties are married. For example, if they are married, the two Hindus. So the statute that governs their marriage is the Hindu Marriage Act of 1955. And the grounds available for divorce under the Hindu Marriage Act are provided under section 13 of that act, under section 13 of the Hindu Marriage Act. Now, unless and until they contest the claim, or rather a relief is granted to this person, to X, on a ground available in the matrimonial law under which the parties are married, under some of the grounds, any of the grounds mentioned under section 13, that judgment cannot be accepted. I hope I am clear. Then the second one, where the respondent voluntarily and effectively submits to the jurisdiction of the forum as discussed above and contests the claim, which is based on a ground available under the matrimonial law under which the parties are married. Either if the respondent is habitually and permanently residing in a foreign country, and a relief is granted on a ground available in the matrimonial law, that is under which the parties are married, or where the respondent voluntarily and effectively submits himself to a particular jurisdiction and contests the claim. He contests the claim which is based on a ground available under the matrimonial law. So tomorrow, like X is able to file a case against Y, stating that he or she needs a divorce on the basis of cruelty. So cruelty is a ground that is available in India. Now, unless and until he or she is able to prove or rather contest a case on any of the grounds that is available in the law of India, that foreign judgment will not be accepted. Then the third one, where the respondent consents to the grant of the relief, although the jurisdiction of the forum is not in accordance with the provisions of the matrimonial law of the parties. What if tomorrow Y says, okay, let there be a judgment against me, let divorce be granted? So then all these principles will not be looked into. It will be a consent decree. If that be so, that consent decree can be accepted in India. So these are the few grounds on which, or rather, this is the conclusion based on which section 13 clauses A to E have been interpreted by the Supreme Court in the 1991 case, which I told you, it's the Narasimha Rao versus I'm sorry, that's a case. That's the case. That is Venkata. That's the 1991 case. That is Narasimha Rao versus Venkata. I'm not able to recollect that name. I showed you in the slides earlier. I think Narasimha Rao and others versus Venkata Lakshmi and another. That's the 1991 3 SEC 451. This is the case which has discussed all the different clauses under section 13 in such a manner that the ultimate conclusion that we read now, or rather we discussed now, has been reached. So this gives an idea as to how far the foreign judgments can be accepted in matrimonial cases in India. So this is basically a Magna Carta as far as this principle is concerned. Then, as I told you, irretrievable breakdown of marriage. These are all several decisions. Anybody who wants to write down the notes can write down these notes. Why I stated this particular ground of divorce, why I highlighted this particular ground for divorce is because most of the countries abroad, they tend to grant divorce on this particular ground. And this is one ground, at the cost of repetition, let me tell you, this is one ground which has not been accepted by the law, in India, by any laws. None of the personal laws accept irretrievable breakdown of marriage as one ground for a contesting divorce. Except, of course, as I told you earlier, by the Supreme Court under Article 142, they have invoked their inherent jurisdiction and granted divorce in cases where there has been an irretrievable breakdown. And that too, since they are not on merits, that does not come under the purview of Article 141 of the Constitution, so that does not become the law of the land. These are some of the decisions. Again, it's an array of decisions based on the ground of irretrievable breakdown theory. Anybody who wants to write down the notes can write down. That's why I'm waiting for it. Then when it comes to matrimonial cases in foreign judgments, I thought I should bring to your notice two aspects mainly. That is, these are all ancillary issues which normally would come to your attention, or which you would come across when you handle matrimonial disputes, and when foreign judgments, when acceptance of foreign judgments, or rather when the parties are living abroad and they are also in a spree in conducting litigations abroad as well. So this is a situation which most of the lawyers would come across. That is the anti-suit injunctions. Now, what are anti-suit injunctions? Anti-suit injunctions are instituted to prevent the opposite party from instituting or continuing with the proceedings in another court in domestic or foreign country. For example, if in Kerala, a person initiates proceedings and the proceedings are being taking place in Kerala. At the same time, the opposite party wants to conduct a case in UK or US or Australia for that matter. If that be so, you can approach the court in Kerala asking for a relief that you can seek for as an anti-suit injunction, asking them not to proceed with the litigation abroad. There is nothing wrong in granting injunctions to that effect. The principle that lies in granting injunctions in such cases is the very same principles under which Section 41 of the Specific Relief Act is, and injunctions are granted. It's the very same manner in which anti-suit injunctions are also granted. In matrimonial matters, the parties may be entitled to invoke different jurisdictions, jurisdiction based on domicile or jurisdiction based on solemnization of marriage, as I stated earlier. So what if a parties whose marriage have taken place in Kerala or in Punjab or in Delhi for that matter, they move the family court where the marriage had been solemnized. One of them moves the court before where the marriage had been solemnized. The other person simultaneously intends to move litigation on for a matrimonial relief in a court abroad, or for that matter in a court in any part of the country. Whether it's in the country or abroad, anti-suit injunctions can be granted by the court. Now, important decisions regarding anti-suit injunctions, you may note it down. Madhavendra Bhatnagar versus Bhavna Lal, 2021, 2 SEC 775. Vivek Rai Gupta versus Niyati Gupta, 2018, 17 SEC 21. You have Dinesh Singh Thakur versus Sonal Thakur, AR 2018, Supreme Court 2094. And the last one, I hope I'm audible. Am I?
Yeah, perfect.
The last judgment which I mentioned is George Koshi versus Sara Koshi. It is a case that has been pronounced by our parent High Court, that is the Kerala High Court, in which the courts have given a very good description, or a totally good. I mean, it has formed a good precedent where anti-suit injunctions can be granted. If I may take you to the specific discussions of this particular judgment. It says, it describes anti-suit injunctions. It describes the anti-suit injunctions after quoting certain important law books as well, and says when between the same parties litigating on the same subject matter and based on the same cause of action, only one court has jurisdiction, it is said to have exclusive jurisdiction. However, if more courts than one have jurisdiction over the same matter, they are called courts of concurrent jurisdiction. In such circumstances, the criteria to determine which is the more appropriate jurisdiction for the adjudication of the matter, either party can elect to restrain the other party not to proceed with the same litigation in the other non-preferred jurisdiction. In such process, courts in different jurisdictions cannot restrain each other. However, the same parties appearing before both the courts in different jurisdictions can seek an injunction to restrain the other party from proceeding in the other non-preferential jurisdiction with the same matter. Such suits seeking restraint of proceedings in one jurisdiction are called anti-suit injunctions. That is what I explained now. That is with an illustration. If somebody has chosen to move a divorce proceedings in Kerala on the ground that the marriage was solemnized in Kerala, but the opposite party chooses to move a matrimonial litigation in a foreign court on the ground that the parties have been domiciled there, the party in Kerala, the party who has moved the Kerala court, can essentially move a petition for an anti-suit injunction, restraining the opposite party from litigating in the foreign court simultaneously. So that is how anti-suit injunctions function, or rather, it plays its role. Another important area which I thought I should bring to your notice is Section 44A CPC when it comes to acceptance of foreign judgment. The difference is Section 44A CPC deals with execution of decrees passed by courts in reciprocating territory. Section 13 is acceptance of the judgment by itself, whereas Section 44A CPC deals only with execution of decrees. But one aspect which we should understand is, or rather we should comprehend is, Section 44A CPC is a secondary procedure. Unless and until the filtration under Section 13 CPC, whether a particular judgment can be accepted in India or not, whether the test of filtration under Section 13 CPC is over, unless and until that part of it is cleared, there is no question of Section 44A being invoked at all. So Section 44A CPC is totally on the execution of decrees, and that too it is in a very limited role, because execution of decrees passed by courts in reciprocating territory. That is, reciprocating territory are those countries which have been notified, which has been notified in the Indian Gazette. Unless and until you form one of these countries, there is no question if a judgment is passed in these countries, you can get them executed in India. That is all that Section 44A says. Acceptability of a foreign judgment and execution of a foreign judgment is totally different. Execution of foreign judgment is a secondary process which has to comply, or rather pass the test of filtration under Section 13 CPC. I hope I have made myself very clear. Now, Section 44A deals with only a very limited purpose, where the execution of a foreign decree of reciprocating countries in India, which have been notified in the Indian Gazette, alone can be used. Like, for example, a judgment in the United Kingdom or a judgment in UAE, one can file an execution petition directly before the district court here, because it's a reciprocating country. These are the 11 countries which come under the reciprocating countries of India, which have been notified in the Indian Gazette. I think UAE came in very late. In 2020 alone, UAE has been included as a reciprocating country of India. Now, before winding up, I think I have to bring to your notice a very important judgment that has been passed by our parent High Court, Kerala High Court, on 15th December 2021, in which there has been a discussion regarding foreign court judgments, acceptance of foreign court judgments under Section 13. The reason why I was at the outset itself, I was happy that a senior lawyer, a retired judicial officer, presiding officer had joined our meeting was that particular senior lawyer had conducted this case. So it was at his instance that I'm bringing this case to your notice, because he's the one who told me that there is a very important decision that has been, it has not been reported so far. I can give you the number of that case, that is Mat Appeal 1148, Matrimonial Appeal 1148 of 2015. It is available in our Kerala website, our Kerala High Court website. It is Sindhu Prabhakaran versus Vijay Balakrishnan and another. It's a division bench judgment. That was a case where the parties got married in one of the districts in Kerala. Parties got married in Kerala, and after that, both of them were living in US. They approached the Californian court. They obtained a decree of divorce, and after that, I think certain other aspects had also been decided by the courts there. After that, the wife comes here. She invokes the one of the local district court here. I mean, where the marriage was solemnized, or rather where they lived. She abides by the principles of jurisdiction, and then she invokes the jurisdiction of the Kerala court and seeks for certain reliefs, like pertaining to property and gold and other things, like money involved and all that stuff. She invokes the Kerala court for that purpose. So what happened was, the family court in Kerala, they dismissed that petition, saying that these are all aspects that you ought to have raised, or rather ought to have come under the Californian judgment, because that is a judgment which has been to which both the parties have subjected themselves voluntarily. So that becomes accepted in India. So if had all these aspects been treated, or rather been considered by the courts there, it should have been done there. There is no reason why you should have come to the court in Kerala right now for invoking these aspects, or rather for claiming these reliefs. But the Kerala High Court, the stand taken by the Kerala High Court is that certain aspects, for example, if the matter is relating to a property concern and the property lies in Kerala, there is no reason why that litigation relating to that property should be agitated in the US in the foreign country. I can give you, I shall take you to the relevant portions of the judgment. It says the parties are not disputing Exhibit B2 judgment. Exhibit B2 judgment is the foreign judgment by the Californian court by which they obtained divorce, as it is conclusive with respect to the matters directly adjudicated upon between them. But Section 13A clearly says that a foreign judgment is conclusive except when it has not been pronounced by a court of competent jurisdiction regarding the matters thereby directly adjudicated upon between the parties. In other words, the foreign court should have competent jurisdiction to adjudicate upon the matters thereby adjudicated upon between the parties so as to treat that foreign judgment conclusive. But here the question is whether the dispute involved in the above OP was covered by the foreign judgment. The dispute involved in the present case was regarding the property that is situated in Kerala. If so, do you think, or the courts held that the courts in US essentially they do not have the jurisdiction to decide on a matter regarding a property that is situated in Kerala. So that be so, the High Court held rightly the family court should have entertained this petition. PW1, father of the appellant, deposed that the settlement agreement attached to Exhibit B2 is the foreign judgment, was with respect to the assets and liabilities of the parties in USA. The settlement agreement that had been attached to the foreign judgment related to the properties as well as the liabilities of the parties in USA. It did not relate to the liabilities or assets or the money involved in Kerala. So essentially, regarding those aspects, the foreign judgment cannot the foreign judgment cannot be conclusive about it. So essentially, those are areas which have to be agitated before the court, which has jurisdiction regarding that matter. So when it comes to property, the way, as we all know, a property can, as the CPC itself says, immovable property, where the property lies, the court has the jurisdiction. If that be so, essentially, you cannot say that the foreign judgment is conclusive regarding the decision of the property that is lying in Kerala. So that is how the judgment goes. That's a very important judgment. It is available on our website also, which will give a conclusive idea as to how Section 13 CPC has to be applied when it comes to foreign judgments. So this is the nutshell of actually how Section 13 works. So Section for Section 13 for a foreign judgment. Yes, the decision. I think somebody has sent a message on the chat box. The party's name is Sindhu Prabhakaran versus Biji Balakrishnan and another. Sindhu Prabhakaran versus Biji Balakrishnan and another. The case number is Matrimonial Appeal number 1148 of 2015. It was decided on 15th December 2021. So therefore, it's in a nutshell, if I should conclude how Section 13 should function, Section 13 should function only if the foreign judgment has been passed by a court of competent jurisdiction, if on the merits of the case, on the basis of any law, that has been accepted and approved by the provisions of the Indian law. The principles of natural justice have to be followed. It should not have been obtained by fraud, or it should not violate any kind of law that is prevalent in India. So all these conditions have to be looked into if a foreign judgment has to be accepted in India. And again, as I told you, Section 44A of CPC is different from Section 13. Section 44A deals only with enforceability of the judgments, and that is, not enforceability, execution of the judgments of the reciprocating territories, whereas enforceability or acceptance of foreign judgments is dealt under Section 13 CPC. Anything in particular if you have to ask? Though it's a very short topic and there are only very few judgments regarding all this. Of course, it's a settled position also, and I think the section itself is self-explanatory on its own. But based on facts, you can always differentiate the judgment, or that's how we'll have to go about it. Any queries you have, you can post it to me.
Yeah, I'm just reading it.
Yes.
This is any timeline with which one needs to file anything in India once the divorce has been given in any country.
You don't have to. That is what I've see. There is no confirmation of a foreign judgment. If a divorce has been granted by a foreign court, if it satisfies all the conditions under Section 13 of the CPC, you don't have to redo the whole process or redo the whole exercise here. So there is no question of limitation in such issues. If it is not acceptable, if you feel that it's not acceptable, then of course you will have to move the courts here, because if it has been given on irretrievable breakdown of marriage in a foreign country, and then you come here and you want to there might not be an acceptance of that particular judgment, unless of course both the parties have subjected themselves to the jurisdiction. If that be so, you can always move the Indian courts on any of the grounds available under the provisions of law here. For that, there is no question of limitation, except that you will have to give an explanation. If there is unreasonable delay after obtaining a foreign judgment, and if you approach the court, you will have to give an explanation why you have approached the courts here and why the delay is. There's no question of limitation as such.
Yeah. It says one of the spouse is in US or who is in the other country, invested along with their spouse in India and family in India. In this scenario, what's the process if property separation is involved in India, and in the case they refuse to do that?
That is, again, I told you, the property that's what the last judgment actually deals with. So property separation means if the property, as far as India is concerned, we are bound by CPC, and CPC clearly states that any litigation as far as regarding title or regarding possession or anything regarding the immovable property, you will have to agitate before the court where the property lies. So there is no point in getting a judgment from US regarding a property in Kerala, or regarding a property in Punjab, regarding a property in Delhi. It's self-explanatory. You will have to move the concerned court in India itself. But as stated in the earlier judgment, if the parties have entered into or rather they have subjected themselves to the jurisdiction of a court abroad, and they have been able to enter into an agreement regarding the properties there, or regarding whatever liabilities or assets or whatever in the foreign country, of course, then that foreign judgment becomes binding. But otherwise, if you want to decide on something that is in India, you will have to approach the courts here itself.
Yeah. How to deal with cases where child abuse is involved and spouse gets divorced outside India? Is there a way that the child can be protected from the abuser legally, given abusers is in India and both the child and other parent is in other country?
Child abuse is a totally different issue. Child abuse as such is not a ground for divorce. Of course, it comes under cruelty and it's a major criminal offense in India. As you all know, POCSO cases are there. But I did not understand how, if you could please repeat the question and Make it clear, like.
Yeah. How to deal with the cases where child abuse is involved and spouse gets divorced outside India? Is there a way the child can be protected from the abuser legally? Given abuser is in India and both child and other parents is in other country. Abuse we may not connote with the
Matrimonial
it can be.
aspect. Okay. Now,
Yeah.
if it's a third person,
Yeah.
if see matrimonial disputes, what we come to know of, or rather we have been seeing also, like there are a lot of issues where the parents, where the spouses find fault with, or rather make unnecessary allegations of child abuse against each other. So I was under the impression it had something to do with the matrimonial dispute as such. But if you want to save the child, and if you're going abroad, and if the abuser or the perpetrator is in India, you will have to move the Indian courts for that. Whatever, if the perpetrator is in, and if the incident has taken place in India also, you will have to move the Indian courts for it.
This is one spouse is in US, cruelty filed in US and got divorced in US. Other spouse and the family members is in India. Based on this foreign judgment, how to deal interdependent things like child right, cruelty, and other financial matters.
That is
they're
that
all
if that aspect, if the I think that the section itself is self-explanatory. If you get a judgment, foreign judgment from US on grounds of cruelty without a proper contest on the part of the wife or the other spouse who is supposed to be in India, and that judgment is absolutely not at all acceptable in India. And as far as the child is concerned, in India, what the law that we follow is Guardian and Wards Act. And Guardian and Wards Act, Section 9 clearly states where the child ordinarily resides. So if you have to move for the child rights, you'll have to move the court where the child ordinarily resides. And if it is in India, you'll have to move the Indian courts itself. It's very clear.
Yeah. Thank you, Parvati ma'am. And it was, as usual, illuminating session. And though the topic seems to be very short, but it has its own implication professionally as well as for the stimulation of the mind itself. Thank you, everyone. Stay safe, stay blessed. Namaskar. Good night.
Thank you.